If I could describe Professor Alisea in one word, I would say intense. He's just so focused on what he does. He expects a lot of everybody who's around him, his students, and I know his coworkers.
He does not tire. He does not stop.
I would say whole, meaning W-H-O-L-E. And that may be a really strange word to use, but here's what I mean. He's not just brilliant, which he is, he's kind. And he's not just passionate, but he's judicious and fair.
There was an assignment when I was in first grade where we were supposed to draw ourselves as our future profession, and I drew myself as a lawyer. So I have wanted to be a lawyer for a very long time.
One of the things I did to start some hiring at the law school was scour recent Supreme Court clerks and came across Joel Alisea.
Ultimately, I realized that as much as I enjoyed the practice of law, it seemed to me that actually my best use, the thing that would be my highest vocation, would be to be a scholar and a teacher.
Joel's had a tremendous impact on our school. I would even go so far as to say a transformative impact.
Professor Alisea is really kind of the engine behind the entire campus, I think. In a quiet way, you might not know how much he does every single day for the students, for the faculty, for the school as a whole.
After 4 years at our school, Joel had already published more top 20 law journal articles than our entire faculty collectively had in its history.
Joel's scholarship is so thorough. He takes no shortcuts.
I think the article I'm most proud of is my article, The Moral Authority of Original Meaning.
The impact that his article on the moral authority of original meaning has had, not just in academic circles, so to speak, but among students. They will mention things like this article and the impact that it's had on their thinking.
If you read his articles, he can take really, really hard concepts and make it so that anybody with a cursory understanding of what he's talking about can pick it up.
The things that he writes about are groundbreaking. So to be able to do all of that in both the breadth, the depth, the quantity, and the quality, I think is practically unrivaled.
The two guiding principles in terms of how I think about my teaching and my mentoring of students are that I want them to know that I'm on their side, and I want them to know that I'm going to hold them to the highest standard that I can.
I took his Con Law 2 class, and then I took his American Constitutional Theory seminar. It would not be an overstatement to say it completely changed what I thought about the law. He just brings something out of every student that he has, and he is such a force of mind.
He is a mentor to me, to I think a lot of the members of the faculty, but I know the students as well. They adore him.
Even when he didn't know anything about me, he was always super nice and kind and wanted to hear what I wanted to do with my life, with my career, clerkships and that kind of thing. And he just kind of took me under his wing, and he would just work tirelessly to help me find judges and work out applications, and to the point where I would be getting emails at 1 a.m. hey Andy, this you spelled the judge's name wrong in this cover letter.
Well, it's a tremendous honor to win the Joseph Story Award, knowing that my own mentors, Robert George and John Manning, were previous recipients. To me, it's really humbling. If anything, it calls me to live up to being a recipient of the award.
Congratulations on the Joseph Story Award. I couldn't think of a more deserving recipient.
Congratulations, Professor Alisea, you really deserve it.
Congratulations, Joel.
Welcome back, everyone. After a brief programming intermission, also known as our dinner, it is finally time for me to announce Spencer Shia. Spencer Shia is the University of Chicago Joseph Story Award Chair and will be announcing the 2026 Story Award winner. I know at the beginning of this dinner I mentioned that I hope you look around and consider who the next big names are, and I feel pretty confident that Spencer Shia is one of those big names. So please join me in welcoming Mr. Spencer Shia.
Good evening. Great Pledge of Allegiance. What can I say? It is an honor to be with you all tonight, and it is my privilege to award and present the 2026 Joseph Story Award. The Joseph Story Award is given annually to a young academic who has demonstrated excellence in legal scholarship, a commitment to teaching, a concern for students, and who has made significant public impact in a manner that advances the rule of law in a free society. Its namesake, Justice Joseph Story, was a prolific scholar, jurist, and public servant, a justice of our Supreme Court, and the inaugural Dane Professor of Law at the Harvard Law School. Justice Story's erudite mind and respect for the Constitution carried the tradition of our nation's majestic founding into the first half of the 19th century. Mindful of Justice Story's legacy, I am honored to present this year's Joseph Story Award, Professor Joel Alisea. Professor Alisea is the inaugural St. Robert Bellarmine Professor of Law at Catholic University's Columbus School of Law. He also serves as the Columbus School of Law's Associate Dean for Faculty Research and the Director of the Center for the Constitution and the Catholic Intellectual Tradition. Professor Alisea received his A.B. summa cum laude from Princeton University, where he was elected a Phi Beta Kappa. He then went on to the Harvard Law School, where he received his J.D. cum laude and served as president of the Harvard Federalist Society and notes editor of the Harvard Journal of Law and Public Policy. Professor Alisea started his career as a law clerk to the Honorable Diarmuid O'Scanlan on the U.S. Court of Appeals for the Ninth Circuit. He then practiced at Cooper & Kirk, clerked for Justice Samuel Alito on the Supreme Court of the United States, and returned to Cooper & Kirk, where he remains of counsel. In 2020, he joined the faculty of the Columbus School of Law, and he received tenure in 2024. Professor Alisea's prolific scholarship centers around constitutional theory. For instance, Professor Alisea's article, Bruen Was Right, addresses Bruin's critics and proposes that Bruen provides a better approach for adjudicating constitutional rights. The article sparked significant commentary even before its publication. His article, Originalism and Truth-Telling, in response, The Moral Theory of Original Meaning, consider the interplay between moral philosophy, the natural law, and constitutional interpretation. And yet, Professor Alisea's scholarship has influence beyond the ivory tower. In 2024, Justice Kavanaugh cited Professor Alisea's practice-based constitutional theories article in his Rahimi concurrence. And Professor Alisea's writings in constitutional law extend beyond law reviews to publications like the City Journal and the National Review. Professor Alisea is a beloved teacher at the Columbus School of Law. To quote the nominating letter from their Federalist Society chapter, Professor Alisea raises the bar for students, encouraging them to think independently and fully grasp the concepts at hand while fostering an environment where students can ask difficult questions and see different sides of issues. Not surprisingly, therefore, he has won multiple teaching awards, including the student-selected Professor of the Year. He is also a devoted mentor of his students, providing them with opportunities to assist in his research and meet scholars, practitioners, and judges. In addition to his teaching and scholarship, Professor Alisea is dedicated to serving his community. He has proven an energetic faculty advisor of Catholic University's award-winning Federalist Society chapter, helping mentor its members and fill its programming. His Center for the Constitution and the Catholic Intellectual Tradition has become an integral part of Catholic University's law school community, hosting events with speakers including Justices Thomas, Alito, Kavanaugh, and Barrett. Professor Alisea's service extends beyond his law school. He has testified twice before Senate Judiciary Committee subcommittees against universal injunctions, and he also mentors aspiring academics. Professor Alicea's dedication to scholarship, teaching, and service is an example for all to follow. And now I am honored to present this year's Joseph Story Award, Professor Joel Alicea.
Well, thank you to Sheldon Gilbert, to Leotis, and the award committee for this tremendous honor. I'm deeply humbled to join the company of scholars who have received this award. Two of the past recipients are my most important academic mentors, Robert P. George and John Manning. While I confess that I feel myself unworthy to share any honor with those two great men, I accept this award in the hope that I may one day live up to their high example as scholars and teachers. Because that's what this award recognizes, scholarship and teaching. We have a particular need for both at this moment in our history. We need scholars who pursue the truth wherever it may lead, and we need teachers who inculcate a love for the truth in their students. These sound like ordinary tasks, indeed the defining tasks of the vocation of a law professor. But in our time, the pursuit and teaching of the truth is far from uncontroversial. When Professor George began his career at Princeton in the mid-1980s, the main challenge came from the denial that there was truth. The dictatorship of relativism, as Cardinal Ratzinger called it, presided over a sprawling empire, encompassing every major legal, cultural, and academic institution in the West, including the Supreme Court. This was the cultural milieu that produced the infamous passage from Planned Parenthood versus Casey, quote, "At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life," unquote. Much of the work of conservative scholars and teachers in the 1990s through the early 21st century was the reassertion that there could be a truth of the matter when it comes to law and morality, and the Federalist Society played a key role in that effort. While there is still a strong strain of relativism in our culture today, that is not the major threat to truth, in my estimation. In some ways, the threat today is more pernicious, an indifference to the truth. It's not a denial that there is truth, but a ridiculing of those who would adhere to the truth when the truth stands in the way of achieving certain goals. This disposition is often the result of good and sincere motives, and it's also the fruit of despair about our future. Those who adopt it are usually deeply concerned about the state of our politics and our culture. They perceive grave threats to all that they hold dear and feel almost hopeless that their way of life can endure. And they therefore cast aside any qualms that stand in the way of seizing power, judicial or otherwise, and using it against the threats to those things that they cherish. This tendency can be seen across the political and ideological spectrum, but it's especially palpable among students and young people generally, which is why I'm making these remarks here in front of you, the students. I have great sympathy for the motivations that undergird this tendency when it comes from the right. I, too, grew up witnessing many alarming and dangerous attacks on the moral and constitutional foundations of our republic by the political and legal left. I, too, saw the weakness of earlier conservative leaders and officials ushering in devastating setbacks. But an ends justifies the means mentality will not lead to the salvation of the things we hold dear. It will put those things to the torch in the name of saving them. It will leave our successors with an inheritance of ashes, because despair can only produce despair. The better path is a firm and abiding confidence in the goodness of the things we defend. Now, that's not to deny that strong action is necessary at this moment in our history. No one has cheered louder than I have at the astonishing successes of recent years, successes that were only possible through a clear-eyed appraisal of our challenges and firm and steadfast leadership in the face of those challenges. Many things that should have been done long ago have been or are being done, and that is cause for celebration. But in pursuing, even aggressively pursuing, those noble objectives, we cannot be indifferent to the means by which we pursue them. We at the Federalist Society are the keepers of a legal tradition whose importance transcends the anxieties of any historical moment. For more than 40 years, this organization has stood against the ends justifies the means mentality that has so long characterized the left and was epitomized by Roe versus Wade. Dobbs versus Jackson Women's Health Organization, by contrast, was not just the greatest human rights achievement in America since Brown versus Board of Education. It was also an emphatic repudiation of the left's subordination of the Constitution to their own ideological ends. The repudiation of Roe was based on the truth that there are moral rights and moral wrongs, and the usurpation of power and the violation of legitimate laws are deep moral wrongs. The Federalist Society has understood this for decades. Previous recipients of this award, like Professors George and Manning, articulated it in their scholarship and taught it to their students. May all of us remain good stewards of the inheritance we have been given by those who came before us. Thank you very much.
Congratulations, Professor Alicia, and thank you for your work and writing in constitutional law. I'll go straight. Next on the agenda is our keynote address about the proper judicial role. It is my honor and privilege to announce our keynote speaker for the night, the Honorable Judge Lawrence VanDyke of the United States Court of Appeals for the Ninth Circuit. Judge VanDyke joined the bench at the start of 2020. Prior to that, he was the Solicitor General of Montana and then the Solicitor General of Nevada. Please join me in welcoming Judge VanDyke.
Thank you, and it's quite an honor to be here. I guess I should start by saying, Sheldon, I will, this will be a PG performance this evening. My good colleague, Judge Johnstone, is somewhere out here in the crowd. Where are you at, Judge Johnstone? There he is. So he's probably, I was going to say, that should go without saying, but I think he would probably, exactly. Yeah, thank you, Sheldon and Peter Redpath and the Federalist Society, and thank you, Morgan, for this. I can't imagine what possesses people to take on these sorts of roles. The selfish part of me never has done anything like that. My behavior on the Ninth Circuit has basically kept me off committees, which I've appreciated very much. But I am eternally thankful for the type of work that people like Morgan put in. So thank you, Morgan, very much. That's good. So it's a little bit surreal for me to be here. I was my very first national Federalist Society event that I went to. I did the things on campus, but I missed the national convention because I was new to law school and didn't really know what I was doing by November. I think I was still trying to find my classes at November. And then, so I went to the student symposium in 2003. And it was, it was surreal to be here now presenting. I would have never thought that would happen. I probably would have been terrified to do that, at that time. Of course, at this point, what could I possibly say that could get me in more trouble than I'm already in? So, but tonight, I'm going to go back, consistent with our theme, 250 years. I'm going to go back further than my first student symposium, further than the very first, when the Federalist Society first started, all the way back to 250 years ago, back when the founders created our system of government, including our federal judicial system. I think 250 years is an excellent time to look back on the history of our republic, to ask where we started, where we are, and how we got here. And I'm going to talk about the judicial system that the framers envisioned and then compare that to the system that we have today. And then I'm going to fast forward and talk a little bit about myself. I'm going to want to talk about how I try to emulate the system that the framers created. But then I'm going to talk a little bit about why sometimes I don't do that. I'm aware of the fact. So the irony of all this is, I did not think his opinion was going to be out by the time that I did this talk. So I remember thinking to myself, like, I wonder if the students will know that I do controversial things sometimes, But I feel like at this point that I don't have to worry about that. So I'm going to talk a little bit about why I do controversial things. So I guess probably an appropriate time to do that. The official title of my talk is The Proper Judicial Role 250 Years Later. But what I really wanted to name my talk, but I was afraid that Peter and Sheldon wouldn't let me, is How Judges Should Behave and Why I Don't. And so I'm very aware that some people, including many judges, and including judges who have a very similar role of the judicial, similar view of the judicial role and a similar view of the law as I do, would characterize some of the things I do as misbehavior. I'm aware of that. So in the second part of my talk tonight, I'm going to try to explain and attempt to defend why I do what sometimes I do, and even if I'm unsuccessful at winning everyone here over to that approach, I hope that at least I might be successful in convincing you that sometimes we do need to do something different in response to some of the judicial misbehavior that I'm going to try to highlight and talk about. So the founders conceived of the judiciary as an important, but in my view, very limited and minimalistic branch of government. In their eyes, the judiciary's role was a subsidiary one, apply the law formulated by the legislative branch and enforced by the executive branch. And that subsidiary role is why the judiciary, as Hamilton envisioned in Federalist 78, was expected to be the least dangerous of the three branches, with the least capacity to annoy or injure constitutional rights. Judges were not supposed to have any policy-making or enforcement authority. Hamilton famously described the judiciary as having neither force nor will, but merely judgment. We've all heard that. But just to say Hamilton's descriptions out loud today sounds almost like the punchline to a joke. More like fantasy or ancient fiction than fact. And there's a reason for that, which I'll get to in a moment. Under the founders' vision, judges weren't completely powerless, of course, but Federalist number 78 described their role as primarily corrective, keeping the political branches within the limits assigned to their authority, rather than setting policy themselves. Hamilton explained that judges would occasionally step in to declare all acts contrary to the manifest tenor of the Constitution void, but that didn't mean judges were going to end up making the final call on most important policy issues, much less every single important issue in society. And as a historical matter, it is interesting to observe the extent to which litigants and judges alike actually appear to have accepted this limited judicial role. Just think, who ran to their favorite Federalist district court to block Jefferson's extraordinary purchase of Greenland? The Louisiana Territory. No one did. It's very telling, right? Nobody did that. When President Jackson unilaterally removed 10% of the federal civil servants and replaced them with his friends and political loyalists, did a Whig judge freeze his removals with universal injunction? No. The officials just left office, and Jackson prevailed in his policy removal at every turn, as Stephen Calabrese and Christopher Yu observed in their article, The Unitary Executive During the First Half Century. And as the Supreme Court reminded us recently in Trump v. Casa, the American judiciary didn't even produce a single universal injunction until 1963. And when judges did rarely step in to limit the other branch's policy judgments, the benchmarks of that corrective authority was never supposed to be the judge's personal policy judgments or political convictions. Federalist number 78 saw judges' authority as limited to merely giving effect to the intention of the people, already incorporated into our foundational documents by the people themselves. In Hamilton's eyes, integrity and moderation were both prerequisites to carrying out someone else's vision, even where it might differ from your own policy preferences. It would be absurd, Hamilton thought, to allow judges to substitute their pleasure to the constitutional intentions of the legislature. And on a similar note, Madison penned a letter in 1831 which described the judiciary's role as merely expounding the Constitution, not altering it. Chief Justice Marshall echoed the same sentiment in Osborne versus Bank of the United States. He said, judicial power is never exercised for the purpose of giving effect to the will of the judge. Now, I want to be clear. I'm not saying, nor would the founders have been so naive as to think that the law is somehow neutral or apolitical. Politics and policy preferences get baked into every law. But our constitutional structure dictates that it's the legislative and the executive branches that do that baking, not the courts. The biblical book of Proverbs warns against a land with many rulers. The founders' conception honored that warning. The new nation would have enough rulers already without having hundreds more judges also throwing their hats in the ring. The founders' approach recognizes, in line with Judeo-Christian principles, that judges are no less fallible than legislators and executive branch officers. The supposed wisdom of judges is not some panacea we can turn to in order to rectify all the supposed follies of legislative and executive actors. So here's a little foreshadowing. It would betray the founders' vision to conceive of the judiciary as capable of swooping in to right every social wrong propagated by the supposedly morally and intellectually inferior elected branches. So the judiciary's role, as envisioned by the founders, was primarily to correct the other branches when they abused the structure of the Constitution, not to affirmatively declare the nation's policy. And second, even that corrective role was supposed to be guided by the intentions of a supermajority of the people, as expressed in the Constitution, not by the judge's personal beliefs. In line with this vision, Hamilton wrote in Federalist number 78 that liberty can have nothing to fear from the judiciary alone. Well, that may have been a little optimistic. As time went on, we've shifted further and further from the founders' vision of judging, and we've ended up in a place that some might describe as wackadoo, to quote myself in a recent dissent. Not the most recent dissent. The Warren Court led the charge with decisions like Miranda, Gideon, and Reynolds v. Sims, inventing constitutional rights based on judges' policy views under the guise of so-called constitutional interpretation. And since then, the development of substantive due process case law in cases like Griswold, Roe, and Obergefell has continued judicial policy-making trend started by the Warren Court. And my court, the Ninth Circuit, was only too happy to extend those decisions wherever possible. These abusive decisions have an asymmetrical, one-way ratchet effect. Even if most judges live up to the founders' ideals, they will be outmaneuvered and bound by a minority of judges willing to set precedent that smuggles in those judges' political, moral, and social views. And then, even judges acting in good faith must apply that precedent that incorporates more and more judicial policy. And because we, like the founders, generally assume that judges are acting with integrity and moderation, that provides a sort of cover for judicial misbehavior to proliferate behind the scenes. I want you to pay attention to that because I'm going to come back to that in a moment. Of course, individual judges have at times decried the court's departure from the founders' ideals, but those objections usually did little to stem the tide. Chief Justice Berger and Plyler v. Doe, Justice Harlan's dissent in Reynolds v. Sims. But it's telling that these kind of perspectives have too often tended to appear in dissents. These days, the near universal assumption is that judges will have the final word on pretty much every policy issue that matters. Indeed, it feels like today, every time the current administration so much as breezes, someone's calling it into court. It's hard to keep up with the flurry of lower court injunctions, whether they be over the administration's immigration actions, personnel decisions, or its decisions for restructuring the executive branch or anything else. And even when the Supreme Court steps in and repeatedly stays the lower court's injunctions, it hasn't managed to stem the tide that much, and our appellate courts aren't able or willing to correct lower courts all the time. As Judge Reinhart notoriously summarized the Ninth Circuit strategy, the Supreme Court can't reverse them all. The rise of manipulable, fuzzy doctrines like substantive due process, doctrines that purport to merely interpret the Constitution, especially permit judges to plant the flag of judicial supremacy as far as they're willing to go, and they're willing to go far. The first line of defense against that behavior is other judges, but history proves that we can't always count on judges to effectively check their own power, and as I described earlier, misbehaving judges like, as I'm describing, only have to prevail occasionally, and then the power of precedent and the one-way ratchet effect does the rest of the work. And with the judiciary having the final word, the misbehaving judges have taken full advantage of the fact that it's very hard for the other branches to check the judiciary. Most of those checks, like defunding, jurisdiction stripping, impeachment, or simply disregarding overreaching decisions, and you hear people calling for this, right? But they're essentially nuclear options that the other branches are understandably and thankfully very reluctant to use. The court that I'm on, the Ninth Circuit, has particularly embraced this expanded judicial role with open arms. For decades now, a majority of the judges on my court have routinely imposed their politically liberal policy preferences on the law. Take immigration cases and habeas cases, for instance. Both areas are supposed to involve significant deference, either to agencies or state courts, but the Ninth Circuit has pared away that deference piece by piece, creating outlets to more or less disregard agency and state court findings whenever we choose. As I recently pointed out in the dissent, the Ninth Circuit disagrees with our immigration system so strongly that we turn the normal standard for granting stays of removal on its head. Stays are supposed to be extraordinary remedies given only when petitioners prove a likelihood of success on the merits, but the Ninth Circuit hands out months or years-long stays of removal automatically in hundreds or thousands of cases that we know with statistical certainty will ultimately prove meritless. Or consider my court's practice of almost universally stamping down Second Amendment rights in somewhere around 75 cases at this point, and relentlessly taking en banc, almost without fail, any occasional panel decision that comes out in favor of the Second Amendment. The ultimate outcome of a Second Amendment case is entirely predictable in the Ninth Circuit, and it's because of the known policy preferences of a majority of my colleagues. That behavior is a far cry from the neutrality and impartiality the founders imagined. We've done that for so long that we've gummed up the works of our circuit with policy-infused precedent, and now even the many judges trying to fulfill their limited role in good faith find themselves often cabined by the actions of the misbehaving judges of years past. The fact that the Ninth Circuit has staked out this reputation for itself isn't really even that controversial. Most people in the legal community would probably agree that the Ninth Circuit has been the most liberal and activist of the federal courts of appeals over the last 50 years. And these activist practices do more than just get the law wrong. They dishonor the founders' vision, and they do long-term damage to the institutional legitimacy of the judiciary. I'm not sure that the founders anticipated what, with the clarity of hindsight, we can now see so clearly. If you set up the judiciary as the decision maker of last resort on every policy question, you're essentially relying on the judiciary's ability to self-police to keep its power from slowly expanding over time. Our constitutional structure gives judges control of the rule book by which the other branches must operate, the Constitution. Is it so surprising then that giving fallible humans such a powerful role, even if designed to be minimal and restricted, might reinforce an inflated sense of our own abilities and judgment? And if judges are willing to act on that inflated view of themselves, it's not surprising that we end up in a country where judges hold the keys to every important political and social policy issue you can think of. And that's a system very different from the one the founders imagined and lived in. And when conservatives are admirably and earnestly selling a restrained vision of the judicial role to a generation of future judges, it's hard to deny that they are simultaneously buying a guarantee that they will be outmaneuvered and bound by the activist rulings of their unrestrained liberal colleagues. So what should we do about that? If you're a judge like me, who would ideally like to embody a more minimalist, deferential, well-behaved view of judging in line with the founders' vision, what do you do? I can only tell you what I do, which apparently is not what anybody else does, but in some parts. But in individual cases, I try to figure out ways not to impose my own view and attempt to be faithful to the original meaning of the Constitution and to the authority that it grants to the other branches. Now, sometimes that can be really hard because the Ninth Circuit has built up mountains of precedent decided by judges who are building in their own policy views, especially in certain areas, like I talked about earlier, immigration and habeas, and other areas like the Second Amendment, where we've dictated modes of review that effectively eviscerate plain constitutional guarantees. I do want to pause here for a second and emphasize that it's not all doom and gloom. The founders' vision isn't completely dead, and in fact, it's important to emphasize that in the overwhelming majority of cases in my court, we do simply apply the law as written. I do, every single one of my colleagues do. The bread and butter of our job, even on Ninth Circuit, are cases that are not particularly ideologically sensitive or don't involve hot-button social issues or the big scary guy in the White House. And even when we disagree in those cases, which happens, and sometimes those cases are really hard cases from a legal perspective, but they're not particularly ideologically freighted cases. Bankruptcy falls within this category. The disagreement, so in those kind of cases, and there's disagreement, that's the kind of disagreement that I would characterize as the type of good faith disagreement that the founders and the other architects of our judicial system envisioned. Just fallible jobs, doing their best, but making mistakes. And that potential to happen and the forecast that would happen by our founders is why we have so many levels of appellate review. And even in those levels of appellate review, we have multiple judges. You know, one thing I learned becoming an appellate judge is I can't do anything on my own. Like, you don't get to do anything. I wish I was a district court judge. Like, you have to find people to agree with you, and that's hard. So good faith error correction is not the problem. Our system strongly accounts for that. I want to emphasize that when I encounter those kinds of mistakes, or even if I think it's merely possible that this is the kind of good faith difference in interpretation that is the reason behind my disagreement with my colleagues, I try very hard not to write a hot or controversial dissent or majority opinion. People don't have, they have the impression I do this all the time, but it's because like you all don't read, most of the stuff I'm writing, which I don't blame you. Like, you write a lot of stuff that's pretty normal. So in those cases, I just dissent like a normal, well-behaved judge, and I try to give my colleagues the benefit of the doubt. Why do I do that? Well, first of all, it's notwithstanding what may be the perception, I value all of my colleagues, and I do value collegiality, and I value protecting the perception of legitimacy for our courts. And even if none of that were true, I actually like all of my colleagues, even those that I think sometimes continue to misbehave by applying their own policy preferences instead of the law. I don't necessarily enjoy when I get a little creative sometimes and light them up. And there's another reason, too, aside from all that, which is, and it's important to realize, I recognize that my unorthodox approach that I take on occasion isn't without costs. I recognize it has costs, and I'll discuss that in a moment. But that still leaves me with a problem. Knowing all of this, that leaves me with a problem. What should I do in the cases where I think my colleagues are genuinely misbehaving by inserting their personal policy preferences in derogation of the founder's vision, or by being forced, maybe they don't even want to, but they're being forced to apply precedent that's already got those built in. And where I think, and I want to emphasize, in the vast majority of instances where I even think that's going on, I don't do anything different. But sometimes if I think it's happening particularly egregiously, well, I could just dissent normally. Sometimes my judicial colleagues urge me to do that from time to time, and I appreciate that feedback. And again, it's mostly what I do, but obviously that's not what I always do. Sometimes, when I'm 100% confident that either my current or past colleagues have simply applied their own policy preferences, which is skewing the case before us, then I will do something different. And I will tell you why. When a court regularly misbehaves in the way that I earlier described, I think there is a bigger problem than just reaching the illegally incorrect result and making bad law. I think a court like that is misusing, or judges that are doing that are misusing and abusing the judicial power entrusted to them by the American people. That is engaging, I would argue, in a form of hypocrisy or deceit. It would be one thing if the judges were open about the fact that they were applying their own liberal political policy preferences. But judges never do that, right? They don't say, well, here's what the law requires in this case, but I'm just going to rule according to my own policy preferences. They never do that. It's all balls and strikes. In fact, I can only think of one judge that ever came close to doing that. And you can guess what court he was on? My court. Judge Pragerson, now deceased, somewhat infamously said during a confirmation hearing, this blows my mind, but if I had to follow my conscience or the law, I would follow my conscience. And he got confirmed. And you have to appreciate the honesty, but aside from that super rare candor, judges applying their own policy preferences instead of the law invariably act like they are simply applying the law. They're being neutral umpires, calling balls and strikes. Everybody says that. And when that happens, there's a sense in which just dissenting normally validates, or at least arguably appears to validate, that kind of misbehavior. And here's why. That type of misbehavior relies parasitically on what you might call the presumption of regularity. The perception that even if judges are getting it wrong, they're just simply making good faith mistakes. Another way to put it is that when judges abuse their judicial role, that only works because it's disguised as a legitimate use of their power. If everyone knew what was going on, the judges would never get away with it. After all, judges don't have their own agents to enforce their decisions. They rely entirely on the perception of legitimacy for either good or ill. And I think that perception of legitimacy is important. So much of the institution and structure of the judiciary is built to promote respect, and that is good and important. We wear robes, we have lots of traditions and formality. People call me Your Honor, whether I deserve it or not. We talk about our solemn duties to the Constitution and country, and those are all good things. Our system expressly does not expect perfection from human judges. Quite the contrary, our system is intentionally built around the expectation that fallible judges will make good faith mistakes from time to time. But the problem is that all of those features that I've been talking about, designed to protect the appearance of legitimacy and respectability, disguise when judges are genuinely misbehaving, when they are abusing the judicial power entrusted to them by the American people by attaching the force of law to judges' personal policy preferences. Writing a restrained dissent that just points out how my colleagues have gotten the law wrong only supports the impression that our disagreement is a reasonable good faith one. It doesn't help the public or legal community sort out the good faith errors from the intentional misbehavior. Instead, there's a very real sense in which normal dissents implicitly enable and validate and normalize activist behavior. Even if opinions with that type of dissent get overturned, we all just assume the majority merely made a good faith mistake. It's like the federal rules of evidence on adoptive admission. Sometimes when a party doesn't challenge a statement, we treat them as tacitly agreeing with it. And if I don't have some way to flag when I think my colleagues are genuinely misbehaving, not just making good faith errors, I think that misbehavior is more likely to fly under the radar. As courts more and more noticeably deviated from the founders' conception of the judiciary's role, I think there may need to be a corresponding increase in the volume and creativity with which other judges try to flag and rein in the abuse, blowing the whistle, calling attention to the fact that the emperor has no clothes, that this isn't just judicial business as usual. Well, how do you do that? Well, maybe by helpfully pre-writing an opinion the en banc court can use to reverse your own opinion when it once again ignores the Second Amendment. Or by hypothesizing about the wonderful circuit of wackadoo. Or maybe by making a video showing that the majority's position blatantly ignores reality. Or maybe, well, yeah, I said it would be family friendly, so we won't talk. So that is why, so things like that is why I occasionally depart from what I think is the ideal judicial role, to essentially be a whistleblower saying that something more than mere good faith errors are going on here. But I do want to address what I think is a very serious criticism of my whistleblowing approach, which is the concern that I am undermining the perceived legitimacy of the courts. And I do agree that the appearance of legitimacy is very important for a branch that depends on the executive to carry out our judgments, as Hamilton noted in Federalist number 78. The founders were very concerned about the other branches bullying what the founders predicted would be the weaker sibling, the judiciary. The appearance of legitimacy is an important counterweight to the powers given to other branches, and without that perception, our ability to carry out the founders' vision would be impossible. So there is some tension between the perception of judicial legitimacy and the urge to call out misbehavior. Ultimately, though, I think we put the cart before the horse when we prioritize perceived legitimacy over actual legitimacy. Treating the perception of legitimacy as paramount, as the inviolable guiding light for judges' every action, requires those in the best position to identify and call out misbehavior to treat that misbehavior no differently than they would be treating an honest mistake. Parties can complain all they want about judges screwing up, but that's just expected from the losers in a case, obviously, right? And it doesn't usually carry much weight. And on the other hand, criticism from those who don't have skin in the game, but are close enough to identify the misbehavior when it happens, is, I think, very important. I think we are doing lasting damage if we put too much emphasis on the appearance of legitimacy over actual legitimacy. That sounds to me like we are saying we need to keep quiet about the bank president embezzling because otherwise people won't trust the bank or the bank president anymore. We bolster actual legitimacy and the judiciary's proper constitutional role when we expose judicial misbehavior. Perceived legitimacy, while undoubtedly important, is just a means to the end of having a functioning court system. But actual legitimacy is an end in itself. When we issue actually legitimate decisions, we are fulfilling the founders' visions. So that's a little defense of why I misbehave from time to time. And yes, I'm fully aware that I sometimes intentionally defy certain institutional norms. And I do actually wish, I don't know how good I'd be at it, but I do wish I was a judge in a different world where I could simply be that ideal judge envisioned by the founders. But that isn't the world that I find myself in. So while I value my colleagues and I value collegiality and I value the perception of legitimacy for our courts, I equally value actual legitimacy, judging the way the founders 2.5 centuries ago designed our system to work. So I offer this deal to my misbehaving colleagues. You stop breaking the norm of how our system was designed to work, and I'll stop breaking those norms that promote collegiality and the perception of legitimacy. Or maybe to paraphrase it in the way our parents would, you start acting legitimately, and I'll start treating you legitimately. I guess each of us must decide for ourselves whether that's a fair offer. So there you have it. That's my account of what I see as the expansion of the judicial role, and straight from the source, that's my defense for what happened yesterday. In closing, I'm going to leave you with 2 thoughts. The first is a question. If it is true that judges are regularly misbehaving in the way that I described earlier tonight, what should I do? Many don't like my approach, and I'm not blind to that. I understand that, and I sometimes don't like my approach either. I have a plaque on my wall that says De Gustibus non est disputandum, which is Latin for there's no accounting for taste. And I'm very open to the possibility that there is a better way to respond, and if so, let's figure that out and do it. But I'm not excited about the option of doing nothing. And secondly, I'll leave you with an exhortation. Whenever you push back against the wrong, what you will do will inevitably be unpopular for much, if not most, of the social circle affected by that pushback. But now more than ever, we need to have judges, lawyers, and people in all walks of life who are willing to do the right thing and call out the wrong for what it is, even when doing so is unpopular. Popular doesn't mean right. So my challenge to you all is, don't be afraid to publicly push back against what you know is wrong. I think the founders would have agreed with me that there are worse things in life than being criticized for standing up for what's true and right. It's truly an honor to be here tonight, and I wish God's blessings on each of you as you go and do exactly that in your careers. Thank you.